As the Trump administration continues to push America down an authoritarian path, it feels like the number of suits brought against it is in danger of overwhelming our judicial system. Joining me now to discuss is former BuzzFeed's legal editor and former deputy editor for legal affairs at Grid News and the current publisher of the essential Law Dork at lawdork.com, Chris Geidner. Chris, thanks so much for being here.
Hello, Andy.
Hello. So I've got the Law Dork homepage open right now, as I often do, and here are some of the pieces you've written just in the past week or so. SCOTUS allows the Trump administration to end legal status for another 500,000 people. Federal judge protects trans care for federal prisoners, blocking Trump order for now. Judge orders Trump admin to let those sent to CCOT challenge Alien Enemies Act removal. And conservatives on SCOTUS give DOJ the go-ahead. Again, this is from the past week, not the past month or even the past year. This feels insane.
I think as the understatement of the century, it's not good. This is certainly not what one wants to be covering in order to feel like things are stable and going in a good direction.
Yeah. And that list doesn't even include Harvard. And then, of course, shortly before this interview, California Governor Gavin Newsom announcing that they would be suing the administration over Trump's federalizing of that state's National Guard. Is our system built to handle this kind of stress test?
Well, we'll find out. That's the ultimate answer. I mean, in some ways it is, and in some ways it isn't. I think in the ways that it is, we've seen it working. The example of lifetime tenure for federal judges. We've seen judges who just in Trump's first term were appointed by Donald Trump to the bench, ruling against him regularly. This term, we have seen, as you just mentioned, the California governor and likely attorney general who has a 2 p.m. press conference that I presume is going to be announcing this lawsuit, are able to use federalism in a way that isn't attempting to keep schools segregated, but using it to actually have the states use their sovereign authority to challenge federal government actions that they think are inappropriate. Those are the ways that it's working. Those are the ways that the framers thought that having this diffuse power across both up and down with federalism and side by side with checks and balances would work. Now, the downside is we've also seen signs of where it's not working, and that is at the top of the judicial branch with the Supreme Court, and almost even more so somehow with the congressional leadership, and just a complete unwillingness to what I think I wrote to jealously guard their power and their role in the system, which is sort of something that the founders thought was like an obvious thing that anybody would do.
Right. Yeah, no, it really is. I've talked about this with other guests. I think it was Andy Craig, just that there was no way the founders could have anticipated Congress sort of willingly ceding its power to the president in the way it's been doing. But let's talk about how the courts have been doing sort of in general. Is it fair to say, we'll get in, and then I want to get into some specific cases, but in general, you mentioned that there's been sort of a failure at the top, meaning the Supreme Court. Is it fair to say that in general, the lower courts, the district courts, the appeals courts have been better than the Supreme Court?
They have, and I think it is notable, and I think one of the biggest changes between the first Trump administration and the second, which is actually pretty surprising in light of the fact that if you were just generically looking at things, you would say, well, in the second Trump administration, there's a bunch of Trump appointees on the appeals court, so it should go better for him. I think the biggest change is that the appeals courts are almost more skeptical this time around. I think the district court judges, one, they're less politicized. They're less likely to be ideological picks. They generally still, even in this era, although maybe this Trump administration will be a little less so, are essentially selected by the home state senators, at least are given much more power than for the appeals court or obviously the Supreme Court. But even with the appeals court judges, we have seen far more willingness to push back and at the very least, keep the Trump administration in a holding pattern than we had seen in the first Trump administration, and I think we saw that with the birthright citizenship executive order, where all of the appeals courts have been in agreement with district court injunctions blocking that birthright citizenship executive order from going in effect. And we saw it to a lesser degree, but it had been kept on hold. Trump's efforts to re up his anti-trans military ban.
Right.
The while the DC Circuit would have let it go into effect on an administrative stay, the Ninth Circuit did keep a district court's injunction there in place, but the Supreme Court stepped in and overturned essentially the injunction in the military ban case because they said that the military can start implementing it, which means they can kick out trans service members.
Right.
So while it's technically a stay pending appeal, it's going to change these people's career and lives. And even with the birthright citizenship case, while we don't have an opinion yet, and they did keep the nationwide injunction in place for now, that's the case that they took the rare step of actually scheduling oral arguments on a shadow docket case. And we had those arguments on May 15th about whether or not the nationwide injunctions blocking the implementation of the order to end birthright citizenship was appropriate. And that's one of those cases that we're waiting to get
Right.
before the 4th of July.
So I want to talk more about this, sort of where something gets stayed at a lower court, and then the Supreme Court says no, we don't need to stay this while it's working its way through the legal system. And I want to bring up something you wrote about on Friday. The Supreme Court issued an order that again overturned a lower court stay on the Trump administration getting rid of immigration programs that give legal status to about 500,000 people. So, in other words, Trump has turned these 500,000 people into basically lawbreakers, even though they were here legally. And a lower court said, let's pause that while the challenges play out. And then SCOTUS just said, no, we're fine with these people now considered to be here illegally while their case is working its way through the justice system. Can you make this make sense, Chris?
I mean, the way it makes sense is they're allowing Trump to have dramatic, broad authority in implementing immigration policy. The way that I've looked at it is that essentially any power that has been exercised previously, even if it had only been exercised on a case-by-case basis, even if it had only been exercised individually, in some cases, only if it had been granted exercise to grant relief to people, and this administration's effort is to revoke that relief. Essentially, for all of that category of actions, the Supreme Court has said, while litigation is going forward, we're going to allow the president, the Trump administration, Kristi Noem, whoever, to exercise that authority during litigation, which, as Justice Jackson wrote in dissent in this latest case, this has happened twice now.
Right.
Once relating to temporary protected status of Venezuelans, a case that came out of the Ninth Circuit, And then this case that you're talking about parole status in immigration, not like criminal justice parole, but essentially stopping your removal and allowing you to get work permit, allowing that during proceedings, that they took that out. And both of those have been taken out. And before there is a final court ruling on whether or not Kristi Noem's actions were legal in either case. And I think essentially what the court is saying, at least the six conservatives are saying, if it's a power that we have given to the president, that Congress, the Constitution, whatever has given to the president in immigration, we're going to give him deference. The sort of one exception to that is due process when they give no process. And that most notably has been seen with the Alien Enemies Act proclamation removals, and then with essentially times when they improperly removed people, and lawyers have been there to sue and represent them and ask for the government to take steps, as we all now are, maybe me more than others, but I think everybody at this point, with sort of orders from courts saying that the government facilitate the return of these people, because facilitate was the verb that the Supreme Court authorized.
Right. It's just what I mean. Look, this is not an original thought. I'm not claiming any genius here, but why is it not the case that it is very clear that if they don't stay this order, this immigration order, that people will be harmed, and possibly irreparably. And whereas if they did stay the order and say, all right, you want to do this, it's now working its way through the court system until we get a final ruling on whether you're allowed to do this, we're just not going to let it happen, because these people's lives will be ruined. And if we put a hold on it, you'll be fine, government.
Yeah.
Why is that not the case? Why is that not the case, Chris?
You're right. I mean, this is essentially what the point that Jackson, Justice Ketanji Brown Jackson, made in her dissent is, I mean, she said that the Supreme Court had plainly botched its handling of this case. And I mean, essentially, her point was sort of twofold. Was one, the government very well could be wrong on the merits, and that is a serious question. There have been serious claims raised. A district court judge issued a ruling saying that he agreed they were likely right in those claims that the government was wrong. And so you've got that as a starting place. But then what she went into is that one of the other factors in granting a stay of a district court's order during litigation is proving irreparable harm. And what her point was is that the government didn't do that. This is something that came up, even, I would say, in a way, on this side of the ledger, even more strongly in the Doge cases, that essentially the government didn't even make a case that there would be irreparable harm beyond, we don't get to do what we want to do if if we don't get a stay of this injunction. Now, what Justice Jackson went on to talk about in the immigration case, and you alluded to, is this fact that on the other side of the ledger, there is tremendous harm that you are creating if you allow the government to bring this into effect. And it's sort of on two levels as well, because you've got the very visceral, practical level that everybody is thinking about, that is like, you're going to upend these people's lives, you're going to like potentially deport them, you are going to make them in a constant state of fear about their livelihood, their ability to stay in this country during litigation before there's a final ruling on whether the action being taken against them is legal. Then, secondarily, there's also a question of irreparable harm that if these people are actually removed, in some cases, it could actually moot their case. It could make it so that their litigation can't even continue. And so essentially, if the government deports them quickly enough, they could make it so that this litigation will never reach a final status.
It's just wild to me. And you know, maybe someone needed to tell the Supreme Court conservatives that a lot of these people are Christians. Maybe that would have helped.
Yeah, it's I mean it's really wild that we're getting these extremely substantive rulings in terms of their impact with virtually no reasoning. That
Yeah.
most recent one was literally a paragraph. There was nothing, and the paragraph is essentially all of the language that it takes to describe what you're doing. Because I mean, obviously, the language we've been using, like you are issuing a stay of an injunction pending
Right.
appeal, and
Right.
then there's this language that the Supreme Court uses when they do that, that it is actually important to think about, because what they do when they issue these stays pending appeal, they're not normally at the Supreme Court level yet. They're still having merits resolution before the appeals courts. And so the language that they use is this language about the stay is granted pending resolution by the Court of Appeals, and if a petition for a writ of certiorari is sought at the Supreme Court, which is the way of asking the Supreme Court to take a case, and until the Supreme Court decides what it's doing. And so, what they're doing, and they've done this in these immigration cases, they did this in the Doge cases, they did this in the military cases. What they're saying is, we're allowing the government to take this action for upwards of a year and a half before there would be an appeals court ruling, a time to request Supreme Court review, Supreme Court granting review, briefing on that argument being held, the justices writing opinions and dissents, and then them releasing it. Like, we're talking about the earliest these likely being resolved being next June. And during that entire time, trans people are going to be kicked out of the military. Doge is going to have access to people's social security information. And these between these two rulings on immigration, upwards of nearly 1 million people are going to have their legal status removed and their ability to be quickly deported. And we know from this administration's actions that they probably will try to deport many of them.
Yeah. Oh my God. It's just, I guess, say what you will about Clarence Thomas, but you know, when you pay him, he delivers. Your standards are higher than my current ones, so I won't ask you to say
Well,
anything
I
about
substantively, I'll just respond to that a little. I would argue it's actually pay him and he'll stay on the court ruling exactly as you want.
well, yes. Yeah.
It's not so much. I don't think that Clarence Thomas changed his views.
No, no.
I think that they wanted to keep him on the court because there is some reporting around the time that he got all these benefactors that he was thinking about leaving. He wasn't liking it. He wasn't able to make money. And all of a sudden, Harlan Crow became his best friend. And all of a sudden, he got this RV. And all of a sudden, he decided to stay on the court upwards now of 30 plus years. And that's notable when you think like there have been a few rulings this term already on the shadow docket and elsewhere that have been 7-2. They weren't Trump appointees who were dissenting. It was Thomas and Alito. In the Alien Enemies Act case, it was Thomas and Alito who were dissenting and siding with Trump there. I think the more that happens, in some ways, the better for the left, because they're less likely to retire and give Trump a chance to replace them with somebody who's half their age. I think they truly are getting an impression we're the only ones who can do this. We need to stay here because we stand strong.
Oh boy, Chris, I got to run, but thank you so much as always for coming on and educating me and hopefully our viewers and listeners, and everyone else. Go to lawdork.com. Trust me. Chris, thanks a lot.
Thanks a lot, Andy.